Actually, in the normal course, the governor is a no-go area. You are allowing a special area to the governor in a matter where also additionally having taken that power, he's not disclosing his mind. I will call it, in loose colloquialism, double whammy. The governor anyway can't enter this house. In the case of a chief minister, a nuanced, limited case, he may enter the house. But having entered the house in an exceptional area, he also gives no reasons. It's a double whammy. It's a double constitutional whammy. The reliance by respondent 2 on file notings and comparative charts, tables or notes analysis as dictated by the governor. Well, I take it when we say dictated by the governor, no governor dictates what your lordship saw. We all accept it. We can say dictated by governor's office, no problem. Don't say dictated by the governor. I don't think anybody here is so gullible to think the governor has the time or what is the interest to dictate what your lordship saw in the files. So let's call it governor's office. Is wholly impermissible. We live in the real world. We have to smell the coffee. We can't be in some other land. Is wholly impermissible in the absence of these documents being placed on record under cover of an affidavit. That also I let go. The affidavit is not put. Let's leave that. It's a point to be noted nevertheless. Moreover, in any event, the impugned order itself refers only to allegations in the petitions and the supporting documents and makes no reference to these charts, tables, notes, analysis in the order. No reference, not one word. Not a word. I've checked it up, and therefore, it is not an order which refers to or is based on antecedent file notings, nor does it endorse, accept, adopt, or in any way engraft such notings. All those 4 words. Endorse, accept, adopt, or engraft. If this principle is accepted, which judicial review can your lordship squash? I am putting the same kind of question in different way. Which lordship will never have a case. The file speaks for itself. I have written an order, matter dismissed. Please check up the file and find the reasons. I have a very impressive staff. I have thousands of pages. I have people making notes. I have dismissed your matter. Check up the reasons from the file. That's not the law, The whole administrative law, public law will fall to the ground. Your lordship's doctor of judicial review, forget Tata Cellular, Ordinary principles of judicial review will not be there. The nature and extent of judicial review as it applies to such actions of the governor, applying his independent discretion. Now, here you are more. Your lordship knows you are going to exceptional area. Therefore, judicial review is more. Therefore, reasoning has to be more robust. The other nuances which have been missed out, with great respect, I say so, in the respondent's approach, must be all the more robust in cases where the governor is exercising a power that ought ordinarily to be exercised only on the aid and advice of the Council of Ministers. Thus, in cases where a different view is taken, the burden is higher to show that there was manifest irrationality. This is a phrase of MP. In the advice of the Council of Ministers, thus requiring the matter to be considered decided independently.
So, whenever the cabinet is disagreeing with the cabinet, the reason should be on a higher pedestal.
A. Starting point is that. B. Your lordship's scrutiny also is correspondingly more heightened on those reasons.
Yes.
It's not, nobody is final. Only your lordship's final, that too on subject to Supreme Court.
Yes.
In fact, the Supreme Court joke is the Supreme Court is right because it is final. It is not final because it is right. Nobody is final except God,
Yes,
but in our hierarchy, the governor is not final.
No, we are reviewing it now. Yes.
So, these two double heightened is important. You are going to an exceptional area. Very nice. Those debates are worth going every time back. When I read those debates, Mr. Ambedkar, there's a huge long debate about governors. He says, why should you not have elected governors? Very strong, genuine proposal, bona fide. Then there's another debate about how will you find good people? So he says, Mr. Ambedkar replies, he says, there cannot be 2 swords in one scabbard. Ek myan mein do talwar nahi.
That's why Article 143 of the debates was reduced to 163.
163, no, and then he says in the debate, he says there can't be 2 swords in one scabbard. Then he says that we are in fact thinking, it's a very interesting passage, we are thinking of nominating governors and the post is so kind of non-active that we are very doubtful that we'll get any applicants for the job. That's not true today, But Ambedkar certainly thought that, Anyway, the idea of a governor was a no-go area in 95%.
No, if you see the Constituent Assembly debates,
yes,
where it was, the draft was drawn first, Article 143 dealt with this. where
Yes.
Governor has to be elected, nominated, or otherwise.
Exactly.
Then 163 is the final form that has come.
In between is this discussion, he said, no, elected means he's also elected chief minister. I am also elected governor, 2 spots in 1 scabbard.
That's why it was
Want to
not.
neutralize him and put him only below the nominated. Then he says nominated also with very little powers. Nobody may want the job at all. Then what is the next point? The power of granting approval under 17A of the POCA is not an independent discretionary power of the governor, but an executive power or executive function which is ordinarily and normally be exercised by the governor only on the aid and advice. This is consistent with both some last sentence in my proposition, wrongly suggested to your lordships otherwise. A broad brush is done. It is thrown, some share at this, on that one word, not exhaustive. Lordship remembers the argument. It's totally wrong. Exhaustive doesn't mean Lordship is rewriting the constitution with a number of new engraftments of the governor's power. The exceptions to this rule are not an open-ended category, nor did the Honorable Supreme Court in some shades to set forth a non-exhaustive list as sought to be contended. Now, real para is, this is IR 154. And there is nothing in the majority which is inconsistent with 154. Nothing. As part of the concurring judgment, there is no variance by the majority to this concurrence. I'll be developing all this, but it's just a summary. The decision is MP Oil carves out a narrow MP Special Police, I'm very sorry, narrow and extremely limited exception where the governor may differ from the aid and advice. Now just see the nuance. Where there is overwhelming material on record on the basis of which prima facie case is clearly made out, and yet the council has refused sanction. I'm taking Wallace. Forget this case, I'm giving the law Wallace. Then to the extent the decision of the council is ex facie or manifestly irrational. Manifestly means ex facie actually. Or relevant material has not been considered, the governor may take a different view. That's the nuance. The findings in para 32 of the judgment, which are cited in the impugned order, relate to manifest irrationality and not to apparent bias. Now look at the error now. This is a matter washed. I don't want to oversimplify, I don't want to exaggerate. Just kindly consider this. The governor, the Honorable Governor cites one para of MP, which is 32. And then entire 5 pages is bias, presumptive. The clarificatory question which my Lord put. Presumptive bias, automatic bias. And he cites this one para. There is a manifest error by the governor himself because the para cited does not touch on bias. It says apparent bias, which means demonstrated bias. Somewhere, he is attending the meeting. Well, demonstration is not difficult. I attend the meeting. Or I don't attend the meeting. I attend the meeting and I say, I will go out to the room and have a cup of coffee. You go and decide. Or I recuse. This meeting is separate. And otherwise the man is fully in every ministry dealing with this subject. It's possible. It happened partly in Antule's case, where I had the privilege of assisting the court. Antule, your lordship sees the file notice that directly is involved in so many things.
Yes.
So now in that case, apparent bias may be demonstrable bias. But if subconscious bias was the test alone, then your lordship doesn't have to go to manifest irrationality. And the moment you have a paradigm of a cabinet, a chief minister and a governor, it's automatic.
No, the two are contradictory. Subconscious, any concept of subconsciousness need not be manifest at all. This is the subconscious level.
Yeah, no, I'm saying subconscious will mean manifest is to create the reasons. Manifest is not create bias. And manifest is create irrationality in the order. I'm saying, if your lordship were to accept presumptive automatic bias, then the law would be that in any case and every case, without examining the reasons of the cabinet for being wrong or right, merely because it is the cabinet and merely because it is the CM, the governor must automatically deny or grant sanction, as the case may be, on the ground that MP means that the moment there are 3 entities, governor, CM and cabinet, bias is established. I don't have to examine the order of the cabinet to see whether it is manifest irrational. I hope I'm clear. That's my proposition. So that's the proposition.
So you're saying that irrationality should be palpable and demonstrable.
In the order? No.
In the order. Only then that would come about. That is your
Means,
suggestion.
well, he must address it. I will let it put it lower. Let me put it lower for my lord is absolutely right according to me in the way your lordship has formulated it. So that is number one. But let us take a worst case against me. I am now deliberately testing. First point is what your lordship has said. That's the perfect formulation for manifest irrationality. But now I am taking a point against myself. Let me assume that the governor doesn't delve into the way your lordship has put it just now. He must show something that, look, I have read para 50 to 80 of this cabinet decision. They missed out that in para 69, this gentleman was actually handling the portfolio, or he gave an instruction, or he did sign the file. This is the error of the cabinet. And therefore, I believe prima facie there should be some inquiry. What the learned governor does is, he doesn't address, he doesn't go down that path at all. He says only, I'll read the order again,
Yes.
He says, because this is a cabinet is deemed to be, I wish chief ministers would appoint cabinet the way the governor thinks they can. A lot of chief ministers would be very wistful to be told that every member of the cabinet is appointed by them. Your lordship knows that, all of us know it. But let us for a minute assume the only reason given is cabinet is deemed to be part of Mr. Siddaramaiah. Siddaramaiah is the head, and the constitution says that the cabinet is represented through the chief minister. He's the first among equals. Therefore, presumptive bias, what your lordship put to me in a question form. Therefore, there is no question of my going and seeing where in para 89 they have messed up or given an irrational reason. I don't need to go there. Why? Because para 32 of MP Oil says so. But MP Oil never talks of bias. I'll read that. MP Oil goes into and says the cabinet is wrong for these reasons. And therefore, the governor must do it independently and decide it like this. This is the error of the approach. Para 2.3.4.
No, are you saying that the governor should not have disagreed with the cabinet?
Not at all.
So his disagreement should have been found in the order.
In
reasons in the order.
In the governor's order.
Governor's order.
Absolutely.
That is your submission.
That is right. I can never say that he can never disagree. That is an extreme proposition, and that will never be said.
So the disagreement should be found by reasons recorded in writing in the order.
First part is just your lordship, full stop on the first sentence. Disagreement must be found in the order. That is enough, full stop.
All right. Yes.
Second part of my lord's formulation. If it is found in the order must demonstrate manifest irrationality in the cabinet with which he is disagreeing.
Why should it be found in the order only if the files contain reasons?
He has to know. Files will contain. He has to. Not by. He has to give some process of reasoning by which he comes to that conclusion.
Yes.
The third part, if the second part is not correct, then the order will say, I grant sanction. Go and find the reasons in the file. Then what is your lordship going to do? Judicial review. What is the heightened judicial review? What is the meaning of manifest irrationality of MP? Your lordship will have then the Sphinx. Then the Sphinx comes in. Your lordship has to dig behind the Sphinx and find out something.
Yes.
Last one. MP police is not an authority for the proposition that there is any presumptive rule of apparent bias. I'm addressing the issue. The lordship's clarificatory question is more pointed, but in a sense, I've addressed it here, partly, without your...
No, I'm just getting clarification what is running in my mind. So you should not...
No, I am very grateful. I am genuinely grateful.
I'm not disturbing your flow.
But I am genuinely, I would not say it otherwise.
Yes.
I'm genuine because it helps us to clarify as we go along. Any query, it's most welcome, but it genuinely helps me to clarify, because this is a matter where we are in the frontiers to some extent. Lordship should get the law right, apply to the facts secondly.
Because the submissions are so much, the horizons are so wide now, I need to take some clarification somewhere.
Great respect. Yes. It's most welcome, and I'm absolutely grateful. The proposition that there is any presumptive rule of apparent bias on the basis of which the governor must always independently consider the matter when an allegation relates. I'm denying that is so. The first sentence. Paragraph 2.3.4, page 5.
Yes, I am there.
The question of apparent bias did not arise in that case. Rather, that case concerned a question of likelihood of bias, also expressly rejected by the Supreme Court at So, subconscious bias is out. Your Lordship, no, subconscious is not likelihood. Likelihood means I must show that there is some facts which will show bias against him. So that was the case. Even that was rejected. But still the matter went the other way. Why? Because of irrationality. That's what is developing now. The reliance on para 17 in the written submissions is misplaced and misleading. The MP Special Police Establishment case is not and should not be read as general authority for the proposition that in every case where there is an allegation against the Chief Minister, the Governor can exercise discretion independently, even absent any irrationality in aid and advice given by the Cabinet. The mere fact that the Governor may, in certain very limited situations, differ from the aid and advice of the Council of Ministers does not imply that every such different view of the governor is to be automatically preferred. Just like every view of the cabinet need not be preferred. My lord is absolutely right in that query, but I'm not suggesting that. In fact, the ability of the governor to decide to differ, this is very important, with that boldface. The ability of the governor to differ is itself necessarily linked to a showing of manifest irrationality of the advice received. And that makes sense, fellows. Your Lordship has a proper governance up to the judicial system then. Somebody gives an advice, don't prosecute him. That is not final, fellows. It can be rotten, can be horrible. Somebody here gives an advice that I agree with that advice. He can be equally horrible, he can be good. And your Lordship is the ultimate master, ultimate meaning in the judicial hierarchy. How does your Lordship do your job, Malas, if these two people don't give anything and they say, we just decide? And the test your Lordship applies will always be of irrationality. Has to be, Malas. There is no basis to suggest in the present case, either reflected in the governor's input or otherwise, that the decision was in any way irrational. Forget your Lordship reviewing, there is no such reason given by the governor. Even the written submissions on behalf of R2 do not canvass irrationality at all. They get stuck, fellows, by misreading 32, the other side, in the submission, and they just quote MP because the governor quoted it, not realizing that the governor never went on bias, fellows, in that case. Rather, the submission is entirely based on apparent bias, assuming it to be a presumptive rule that where there is an allegation against the Chief Minister or member of council, the council is automatically disentitled or disabled. This is exactly the query I think now, Malas, it fits in, which your Lordship put to me. It's exactly that issue.